Ladies and gentlemen, just I have concluded necessary formalities for the formation of a valid marriage. Now the next point to be explained for the audience is that is the classification of Muslim marriage. Uh, Whereas it must be clear to the audience that in fact under Muslim law, there is only one form of the marriage that is known as nikah or marriage. But since nikah is a union of two persons, uh, therefore this union of the two persons, after conclusion of the union, it gives rise to a number of reciprocal uh, rights and obligation known as spousal rights and obligation. Therefore, having regard to the rights and obligation flowing from the union of the marriage, Muslim marriage has been classified into three classes. Uh, Therefore, I can say that having regard to the nature of the rights and obligation, spousal rights and obligation, Muslim jurists have classified nikah or Muslim marriage into three categories, uh, and they are: number one, valid marriage. One type of the marriage or one class of the marriage is called as valid marriage. Uh, then other is irregular marriage, and the third is void marriage. So the Muslim marriage is classified into three: valid, irregular, and void marriage. Valid marriage is also known as Sahih marriage. Irregular marriage is called as Fasid marriage. Fasid nikah. Sahih nikah, valid marriage means Sahih nikah. Irregular marriage means Fasid nikah. And the void marriage means Batil marriage. So now, what is the valid marriage and why is it called as valid marriage or Sahih marriage? According to the Islamic jurists or according to the Muslim law, when a union of the marriage is constituted, uh, in compliance, in strict compliance of all the necessary conditions or prerequisites of a Muslim marriage, then such union of the marriage is known as valid marriage or Sahih marriage. Remember, again I repeat, that when the formation of the marriage or formation of the union of the marriage, or when the nikah is solemnized by the parties in strict compliance of all the five conditions necessary for a valid marriage, then such union of two persons will be called in legal sense as valid marriage or Sahih nikah. And what are the conditions? Just I have pointed out a few minutes before, that there must be a proposal, acceptance. Proposal and acceptance must be in one and same meeting in the presence and hearing of the competent witnesses, and it must be with the mutual free consent of the parties. And last, that parties should not be within the prohibited degrees of relationship at the time of solemnization of the marriage. So these are the necessary conditions for a valid marriage. And when two persons of the opposite sex, they unite with each other in strict compliance of all these five conditions, then uh, this union of the two persons will be formally called as a valid union or valid marriage or Sahih nikah. And when the union is valid, or when the marriage is nikah is Sahih, it will give the legal effect of this union will be entirely different from the union which has taken place in violation of certain conditions prescribed for the formation of Muslim marriage. So when the union is valid, when nikah is Sahih, the legal effects of this union will be that after the marriage, parties will have a socio-legal status, that is, male will get the status or will have the status of the husband, and the female will have the status of the wife. Means valid marriage will confer a legal status on the parties to the marriage. One will be called as husband, one will have the status of the husband, and other will have the status of the wife. And after the marriage, husband and wife will be entitled to the copulation with each other. Means they will be entitled to cohabit with each other. They will be legally entitled to form a society, and that society will be called a society of the husband and wife, and therefore they will be entitled to have access with each other for sexual pleasure uh, at the right moment, uh, at the right. So means that copulation between the parties to the marriage becomes lawful, valid. Number two, that next, that wife will be entitled to the amount of the dower. As soon as marriage has concluded, wife will be entitled to the amount of the dower. If amount of the dower is fixed, she will be entitled to that. If it has not been fixed, it may be subsequently fixed, and she will be anyhow, wife will be entitled to the amount of the marriage arising as a necessary legal incident from the contract of the marriage. The third is that wife will also become entitled to the reasonable amount of the maintenance from her husband. This is the maintenance is one of the right, dower is one of the right flowing from the contract of valid marriage. In the same way, maintenance is one of the rights which to which the wife is entitled, and therefore after the after coming into existence a valid form of the union or valid marriage, the wife will become entitled to the maintenance, and uh, uh, after the marriage, valid marriage, uh, wife will be entitled, they will have the mutual right of the inheritance. Means in the event of the death, widow will be entitled to succeed a certain portion of the property of her deceased husband, and in the event of the death of the wife, the husband will also be entitled to succeed certain portion of the property left by the deceased wife. The share of the widow in the property of the deceased husband is 1/4 or 1/8. it depends upon attending facts and circumstances. I will explain it when I will discuss Muslim law and inheritance. Inheritance. In the same way, when the husband wife dies, then husband will be entitled to succeed the property of his wife, and his share in the property of the wife will be 1/2 or 1/4, as the case may be. It depends upon the attending facts and circumstances, as well as the presence and absence of other legal years. And uh, one other legal effect of a valid marriage is that in the event of the death of the husband, if a valid marriage has there is a valid union between male and female, and there is a death of the male, then the female wife will be entitled to remarry only after the expiry of the period of death. Even if a dissolution of marriage has taken place, even in that very situation also, the divorcee will be entitled to remarry with a person of her choice only after the expiry of period of the iddat. Or in case of the death, the period of the iddat is 4 months, and in case of the dissolution of the marriage, period of the iddat is 3 lunar months or 3 months and 10 days. However, if at the time of the death widow is pregnant, then the period of the iddat will extend till the delivery of the child. And in case of dissolution of the marriage, if a divorcee was pregnant, then period of the iddat will also go up to the until the expiry of until the delivery of the child. So uh, these are the some legal effects of a valid Muslim marriage. If the union is valid, then the legal effects of this will be that it will confer the status of the husband and wife. Wife will be entitled to the dower, wife will be entitled to the maintenance, wife will be entitled to marry in case of the death only after the expiry of period of the iddat, in case of the divorce after the expiry of period of the iddat, as the case may be. And they will also have the mutual right of inheritance in the event of the death of either of the spouse during the continuance of the marriage. Now friends, the next category of the marriage or class of the marriage according to the Muslim law is that is the irregular marriage. Uh, I have already pointed out that one there are certain legal prohibition for marriage. Legal prohibition may be absolute and legal prohibition may be temporary or may be relative. When legal prohibition is absolute, then they will be absolutely prohibited to marry with each other. And in case parties are absolutely prohibited to each other on the ground of consanguinity or on the ground of the postage, despite it, if they marry with each other, then the marriage will be white marriage. But if the prohibition for the legal prohibition for the marriage is relative or is of temporary nature and marriage takes place, then marriage will be irregular. Therefore, when there is a formation of the union of the marriage uh, in violation of or in contravention of temporary prohibitions or temporary prohibitions or relative prohibitions, then marriage will not be void, rather the marriage will be irregular marriage. This marriage is called as Fasid marriage, and it can be subsequently regularized by removing the temporary prohibitions. Uh, Temporary prohibitions may be due to unlawful conjunction, For example, one cannot marry, and that may also be on the ground of religion. Say, for example, one is uh, not allowed to marry with a adulteress or a non-Muslim, according to the Islamic jurist. However, if a Muslim marry with a non-Muslim, then means he has married in violation or in contravention of that temporary prohibition. This is a temporary prohibition. And subsequently, if the other party who was non-Muslim at the time of the marriage, she has accepted the religion of the Islam, then the marriage will automatically regularize, will become regular. Uh, in the same way, uh, according to the Hanafi jurist, uh, for the marriage, the offer and acceptance for the marriage or marriage should take place in the presence of the competent witnesses. However, if the marriage between two persons or a union has been formed for the want of the witnesses or without witnesses, then according to the Hanfi, Shafi, and Hanbali school, marriage will be irregular, and it can be regularized subsequently by making the marriage public, or by publicizing the marriage, or by making two persons as a witness of this union. However, according to the Maliki and Shia, this marriage can be solemnized even without witnesses. According to the Shia, witness is immaterial. Marriage can be solemnized with witnesses or without witnesses. If it is solemnized with witnesses, well and good. If it is solemnized without witnesses, even then the marriage is valid. This is not irregular. But according to the Hanfi, Shafi, and Hanbali school, a marriage without witness is irregular, and therefore subsequently it can be regularized by making two persons as or by giving the information to persons that they have married with each other, and in this way this temporary prohibition can be removed. Now, for similarly, friends, marriage during the period of iddat, if a woman is undergoing the period of iddat due to the dissolution of the marriage or due to the death of her husband, marriage with such women is not allowed according to the Muslim. But if a marriage with a woman who is undergoing the iddat due to the death of her husband or due to the dissolution of her marriage, then such union of the marriage with a women undergoing the iddat will be irregular marriage. It will not be white marriage. It will be irregular marriage, and it will automatically regularize after the expiry of the period of the iddat, and cohabitation between the parties after the expiry of the period of the iddat will automatically uh, make the marriage as valid marriage or Sahih marriage. So, uh, irregular marriage may be either lawful or it may be unlawful. Unlawfulness may be either absolute, I have already pointed out, or relative. When it is unlawful, a marriage is inflicted of unlawfulness due to the relative or temporary prohibitions, then such union of the marriage will be only uh, unlawful marriage, and following are irregular marriages. I have already pointed out: marriage without witness, marriage with a woman undergoing the iddat, marriage with the uh, marriage with their two sisters at the same time, and marriage with the fifth means if under Muslim law a person is allowed to marry up to four women at a time, but if he goes for the fifth marriage, then fifth marriage will be irregular marriage. However, uh, if subsequently he divorces one of the wife or dies one of the previous wife, then fifth one will also become valid marriage. Mm. So irregular is another uh, class of marriage recognized under Muslim law, and uh, its effect are entirely different from valid marriage. Then the wide marriage. Wide marriage has here wide marriage, and this is also called as Batil marriage. Uh, Friends, white is a legal word. It is a legal phrase or terminology. And wide means of no legal consequence. Any act or transaction, any human transaction which is wide means it will be of no legal consequence. On the basis of same analogy, where a union of the marriage is wide or batil, it will be of no legal consequence. No legal consequence, no legal effect will flow from the wide union of the marriage. And it will not be worth calling a marriage. Uh, Therefore, if the two persons have united with each other, uh, by complying necessary formalities prescribed for the formation of a valid marriage, but at the time of solemnization of the marriage, parties were absolutely prohibited to marry with each other, and they marry with each other, then such a union will be called as void union of the marriage. It will be illegal. Void means that it will not be enforceable in the court of the law, and illegal means that no consequences, legal consequences will flow from this union. However, a union will be void only when it has taken place between the two persons who are absolutely prohibited to marry with each other on the ground of the consanguinity or on the ground of the fosterage. For example, if one is marrying with his real sister, with his real aunt, with his paternal side or maternal side, or there is any other lady, because there are 13 relations with whom one is absolutely prohibited to marry. If one happens to marry with either of them, and marriage has taken place, union has taken place in compliance of all the necessary conditions, even then this union will be of no consequence. No legal effect will flow from this union. This union will be called as wide union, and the legal effect of wide union is that it will be no union, and the parties will not have the status of the husband and wife ever in the life. They will not be entitled to, they will not be legally entitled to have physical access with each other. Wife will not be entitled to the amount of the dower, as it happens in the case of valid marriage or irregular marriage, and even wife will not be entitled to amount of the maintenance during the continuance of valid marriage, or after there is no need of the divorce, because scope of the divorce is only where the union is valid or it is irregular. But if the union of the marriage is void ab initio, there is no the rule of the divorce will not be, because there was no valid union. When the union was not valid, it will not follow, no legal consequence will flow from it. Therefore, it will be simply, it will be just a so called union without any legal effect, without any valid consequences. So, the wide union normally will be that union which has taken place in violation of or in contravention of absolute prohibition that normally arise on the ground of consanguinity or on the ground of fosterage. If it has taken place in violation of these two conditions, then marriage will be void and it will be void ab initio, will not confer any status, and spouses will not be entitled to any kind of the spousal rights and obligations that normally arise from a valid Muslim marriage. So with this, I thank all of you for bearing with me uh, and listening my lecture. Thank you very much.